Thank you, Pauline. It's great to be here this afternoon. Um, as she has indicated, our office has worked with Elkhart County. I've worked with the county auditor's office for many years, and it seems as though the real estate issues are a recurring issue. They seem to come back. People change in the auditor's office, move on to other positions, get promoted to other areas, and of course that necessitates the requirement that people, as they come in, get more training and get familiar with the real estate issues, even though perhaps we've had to deal with a similar issue in the past. What I've set up this afternoon for you, when we were asked to speak on the subject, the topic was indicated to be basic real estate issues, reading legal descriptions, issues with respect to transfers. I reached out to the Allen County Auditor's Office as well as the Elkhart County Auditor's Office and asked about what kind of real estate issues they would like to see addressed this afternoon, and came up with several areas that are all related to the real estate responsibilities that the county auditor has. To give you an idea and to have an idea of what to anticipate this afternoon, I've set this up in 4 different areas. One is with respect to the auditor's role and the responsibilities with respect to real estate. Different types of real estate ownership. It seemed to me that in trying to address questions about legal descriptions and transfer issues, you really need to have a background in terms of what is the auditor's role in this process, and how does the real estate ownership, how does that work into questions with respect to real estate and those transfers. Between sections 2 and 3, I anticipate giving you a 5 to 10 minute break. It's a beautiful day out there, and to sit here for a long time, I'm afraid you may get a little drowsy after lunch. And this would also give you an opportunity to think if there are any questions that you have come to mind as we go through this. And then we'll come back and talk about legal descriptions and transfer issues, and there'll be an opportunity for questions after that as well. Under Indiana Code 6-1.1-5, that's actually an entire chapter, and it deals with the real estate records, plat and assessment records under the property tax statutes. Generally, the first 3 or 4 sections there deal with some of the roles and responsibilities that the auditor has with respect to maintaining what are called the real estate plat maps. Some county auditors may have the traditional books and papers, records in terms of what you maintain in terms of keeping the real estate current in your county. You may also be more advanced in the sense of going technological and having these types of things on computers or GIS systems of that type. But essentially, the real estate plat maps, maintaining the tax numbers and indices of those tax numbers, and what are called transfer books or transfer cards, depending upon your county, are the responsibility generally of the county auditor. Now, in some counties, I anticipate this is probably not true for you, or you probably wouldn't be here. Some counties, some of those responsibilities are associated with the surveyor at times. In some cases, the assessor is responsible for some of these responsibilities. But in most counties, these areas fall upon the county auditor's office to maintain. In a specific statute under Title 36, the recorder is permitted to record a deed of partition. That would be a parcel that has gone through a court process where the court has distributed or allocated portions of that real estate to multiple owners. It's called a partition action. A deed of partition, any conveyance of land, or an affidavit to transfer real estate only if it has been endorsed by the auditor as either, quote, duly entered for taxation, subject to acceptance or final acceptance for transfer, not taxable, or duly entered for taxation. This is the first look, you might say, that the auditor has at a real estate instrument before it is permitted to be recorded. The recorder is to look that you have actually endorsed that instrument. This is the first opportunity where the county auditor can take a look at that in terms of, are the right parties identified? Is the legal description properly identified? Tax code number and things of that nature for purposes of allowing that instrument to be recorded. The recorder, of course, is supposed to be the one who enforces this section. If it comes to them for recording, they should be sending the person back to your office for that endorsement. Now, there's the three different endorsements. Obviously, a non-taxable transfer is one where, you know, the property would already be subject to governmental ownership, something of that nature. It may be a property that has been previously recognized as non-taxable, although it could be that after that transfer it would no longer be exempt. And the two other transfer endorsements, duly entered for taxation if everything appears to be in order, or duly entered for taxation subject to final acceptance, means that you could allow it to be endorsed and proceed with the recording process even if there might be an error in it so that the instrument can be recorded, but you have still not accepted it for transfer. And that is one of the responsibilities is obviously maintaining those transfer cards and plat books for consistency with respect to your records. Now, with respect to that endorsement section as well, before you are required to make an endorsement, the county is permitted to have a requirement that the property with respect to the affected real estate have the tax identification number placed upon that instrument. The tax identification number, as you are all familiar with, is something that is subject to approval of the State Board of Accounts, and that tax identification number is then used for purposes of administering the property tax statutes. So before the recorder is permitted to record for a conveyance, there's supposed to be the endorsement. And before the county auditor puts the endorsement on, the taxpayer identification number or property tax parcel number is supposed to be on that instrument. Now, the statute does indicate that the county auditor should provide assistance if a taxpayer or person coming in for recording does not know how to obtain that or does not have that number. But before you would proceed with the endorsement, you are permitted to require that that taxpayer or tax parcel number be a part of the instrument. Now, depending upon what your county has done, subsection D allows the ordinance to establish that fee be for each deed or be for each legal description that is part of the real estate that's contained in the deed. And those fees are to be then used for or placed into dedicated fund for maintaining the plat books. Under the, those first two statutes were in the provisions dealing with the auditor and recorder under Title 36. This next statute is under Title 32, which is the real property statutes. In this case, this is an area where generally the auditor is responsible, but also the township assessor, if you had any of those, could be part of this process. If an instrument is brought in that is to transfer fee simple title to less than the whole of the tract, and that is that it's going to be divided into at least 2 parcels or more parcels, before it can be recorded, the auditor or assessor may require that a drawing or other reliable evidence be provided for that real estate. The drawing, it could be prepared by the property owner. It could also be a specific survey, more specifically, and accurately a survey. But that is supposed to contain the number of acres in each new parcel being created, the existence or absence of improvements on each new parcel, and obviously that has to do a lot with what the assessor will do with respect to the parcels and how to keep the values allocated, as well as the location within the original tract for each new parcel. So before the county auditor endorses that instrument, you can and should require that the drawing or survey be provided that would then show specifically where those parcels are, what kind of improvements are associated with them, and acreage. The statute provides that if the instrument that is accepted for recording then bears the endorsement, it's presumed that the auditor has received the necessary information in order to make the proper reflection of the records on the tax parcels and the plat books. So again, this is something that the recorder would be looking for when the instrument comes to them, again, for that endorsement. It's kind of an assumption that when it gets to the recorder, if it has the endorsement, then it has satisfied the requirements for the auditor with respect to the tax parcel number, with respect to division of parcels, and with respect to the legal description and information that generally is provided and reviewed by the auditor on the first step. Now back to the property tax statutes at Indiana Code 6-1.1. Subsection A deals with a property where the owner is creating, again, from a larger parcel, dividing parcels, for example, or combining smaller parcels into a larger parcel. And again, the instrument is to be submitted to the county auditor to be duly entered for taxation. But before this occurs, and before the auditor can determine whether or not the assessed values can be allocated, there's some additional requirements under subsection D here. Where if the parcel is to be, under subsection A, is going to be combined or divided or consolidated under another section, or if it's going to be platted, the auditor is supposed to verify that the real estate has not had any delinquent property taxes at the time. The county auditor is not to apportion delinquent real estate taxes among the owners. And the statute provides that the owner or owners are to satisfy all the property taxes for which the due date has passed as of the date of transfer for those parcels. So if you're dividing parcels, or if you're combining parcels or platting parcels, there shouldn't be delinquent property taxes. Those should be required to be paid before, again, as this statute refers to, before the endorsement would be permitted for to be duly entered for taxation. And If you flip back to A, it's before the owner records the transfer, that is supposed to be taking place. So again, most of this really, it's kind of a gatekeeper concept for the auditor, where most of these things aren't that the auditor refuses an instrument, it's that if they haven't satisfied the requirements for the tax parcel number, for the endorsement, for the split or combination, paying the property taxes, then the recorder is the one who should not be accepting that instrument for recording. But your process is to look at the instrument for purposes of transfer and reflecting those in your plat books and your transfer cards for purposes of property taxation. And then the last section here that deals with some of the responsibilities for maintaining those plat books and tax parcels. Subsection 16 is one where the owner can make a written request, and this written request is actually made to the assessing official, which would typically be the county assessor, in which they can request that if they have more than one contiguous parcel in a single taxing district, or if there's multiple taxing districts in which they have contiguous parcels, they can request that those within each taxing district be consolidated into one parcel. Now the difference here, there is a difference. The person can actually request that this consolidation be made to combine those parcels. That doesn't actually require that any instrument be recorded or that a deed be prepared to combine parcels. This is simply, they're saying, I have 2 contiguous or 3 contiguous parcels, I'd like it to be taxed as one parcel. They can make that request of the assessor. But again, the responsibility here is that this is still subject to section 5.5, where the property taxes are supposed to be paid before those kinds of combinations occur, and the combination then would allow your office to combine the parcel numbers or the parcels into one tax parcel number. Now, with respect to real estate ownership, some of these concepts become very common and regular to someone like me, who's been in practice 30 years. We deal with these things on a daily basis. But a lot of these concepts are not necessarily something that people in the general public are aware of, and what are the consequences in terms of the different types of ownership. Different types of ownership lead to different requirements with respect to execution of documents, who would have to be signing a deed or a conveyance or any kind of a mortgage or other instrument for the real estate. They also have consequences dealing with what happens upon death, or what happens upon the person being incompetent, and how are those instruments then, or how is that real estate handled. Tenants by the entirety is a common type of ownership, which historically I've always referred to as simply as husband and wife. Everybody wants their deed A and B as husband and wife is a common way, but with the change recently with respect to same-sex marriage, we're getting back to now kind of the more traditional concept of tenants by the entirety. That's what it's always been, but most of the time people have simply shortened it and referred to it as husband and wife. Now, tenants by the entirety, you may be getting deeds in, or eventually will, where it will refer to, A and B, a married couple. It may not be husband and wife, but they will be married. But tenants by the entirety, and that kind of a concept, is the same as the husband and wife. Tenants by the entirety is a special kind of ownership. It has all of the common features of joint ownership where upon the death of one, the property passes to the survivor, but it also has a special protection for debt purposes. The debts of one spouse do not attach to property that is owned in tenants by the entirety. But in terms of ownership and the passage of title, it's very similar to the second category I have up, joint tenants with right of survivorship. Joint tenants with right of survivorship, you can have multiple parties, and the common law reference to joint tenancy is that these individuals have what's called an ownership in the whole. It is not that they have a percentage interest or a partial interest. It's considered that they have a right to the whole. And upon death of one joint owner, the property would then succeed to the survivor. And if there's multiple, then again it could continue on to the ultimate survivor. Joint tenants with right of survivorship has a peculiarity in the sense that if a person that's a part owner there decides to convey their interest, that's what's called, it severs the joint ownership. They then become the third category, tenants in common. If the joint owners, joint tenants with right of survivorship, if one of them conveys their interest, that destroys, it severs what's called the joint tenancy, so that the right of survivorship no longer continues to survive. In a tenants in common ownership interest, you typically have multiple parties with percentage interests or fractional interests. They can be quarter, half, thirds, eighths, sixteenths. You've probably seen all kinds of combinations in your offices. Tenants in common, each individual person that has an interest has a divided interest in the whole, or a percentage interest, which they own individually and which they can control and pass upon death through their will or through their trust or something of that nature. It's an individual ownership in the whole. So a death of one of them does not automatically pass to the others. And that's a concept that is really not, I don't think, very familiar with a lot of people in the general public. In reviewing, examining abstracts and examining title records over the years, there's many instances where I've found where people had tenants in common and they continued to pass the property on and simply assume that it went to other owners, other tenants in common when they passed away. And they didn't do anything with respect to opening an estate or addressing that tenants in common interest. Another type of ownership would be a trust. Trusts can be revocable, typically referred to as living trusts, revocable trusts. They can also be irrevocable and cannot be terminated. But they both have the same concept in terms of the ownership is controlled by the trustee or trustees. So when you're looking for transfers dealing with a trust, you're going to be looking for documents that are executed by the trustee or trustees. An estate, there's so many different kinds of ownership. Typically, an estate is the situation where the tenant in common or an individual who owned real estate in their own name passed away, then that property is going to be subject to ownership through their estate and controlled by their personal representative or executor. Again, with with estates, you may find that you'll get deeds from the executor or personal representative where through the court process the real estate has been sold or has been transferred through the estate itself. You can have the process where the actual beneficiaries or heirs receive that property through a distribution through a final account and court order where the court determines who is entitled to that real estate, with that real estate then passing to certain heirs or certain beneficiaries. Typically, an estate doesn't necessarily have to record anything because it's a court record, but for purposes of your office, you need to have evidence of that final order if it's not going to be transferred through a deed so that you would then be able to track that ownership. It's a very common question as to, how does your county address that kind of an issue? A court order certainly could be recorded, and my recommendation when dealing with these things is always to record something, because then it's a public record and you've got it memorialized in a way that you can find it and you can track it. There's many situations where instruments are turned over to the auditor's office, and sometimes they are, quote, filed, but there isn't really a good recording system for maintaining those records for finding, well, what happened to that, or how did it actually get transferred to this person. Another type of, not actually ownership, but another way that real estate can be transferred from an owner is through an affidavit. Similar to the estate, where you don't have the full court process. You may have heard people refer to small estates. There's some state law dealing with estates of a certain size. Generally, it's around $50,000 exclusive of other mortgages or liens, where you don't actually have to open an estate, and the assets can be handled through an affidavit. So you may end up with a procedure where an estate affidavit or a small estate affidavit is filed. You could end up with the situation where, again, the real estate was in an estate, but no estate was done, and then years later it's discovered that person A actually owned real estate and nothing was ever done with respect to how does it get transferred. And then you may get an affidavit in aid of title where all of the heirs or a representative of the family will give a statement of exactly what happened in terms of upon the death of A, who were the heirs of that person. Who were the children? Did they have any grandchildren? Were there any other heirs? How did the ownership pass through the family to the ultimate person who's claiming now, or persons, that they are the owners? And another common thing would be an affidavit of adverse possession, where we've had many instances where a parcel will be left on the records for years and years and years and nothing has ever happened, and then someone will come in and claim adverse possession. And that kind of an affidavit will refer to all of the statutory requirements for ownership and the possession of the land for a certain period of time that is exclusive and is open and was hostile to the owner, and that they've paid the property taxes, that they've been in possession of it, that they've given basically notice to the world that they are the owners through their occupation and use of that real estate. Probably the more common thing, affidavits of adverse possession years ago were probably more common. It's not that people tend to sit on their rights as much as in the past. But affidavits of adverse possession can be used very well when you're trying to confirm an owner that may have had title in their name for many years, but then it's discovered that somebody else might actually have a claim to that real estate. And the affidavit of adverse possession can help to cut off those kinds of questions and issues by certifying and confirming that no, this person who may have been an heir or a beneficiary 15 years ago has lost their rights because of the way that the property has passed and the fact that they have not taken any action in order to preserve what rights they might have had. Another type of ownership would be what's called a life estate. A life estate is an interest in real estate that is measured by the length of life of the person that is referenced. It could be an individual. If I were to convey the property, a property to my children and then reserved a life estate for myself, that would then be measured by my lifetime. You can also convey real estate to party A and measure it by subject to the life estate of someone else. A life estate itself is measured by that lifetime, and it is technically a transferable interest, although it doesn't happen a lot because of the question of how do you sell it or what value is it. But life estates can create some issues because, as you're probably familiar with, life estate can have a bearing upon who's entitled to a homestead exemption based upon occupancy and their interest in the real estate. And then the question becomes, well, when that life estate ends, how do you know that it ends? Or when that life estate ends and people are trying to transfer the real estate again, how do they reflect of record that that life estate has been terminated or it has expired? Again, the best practice, in my view, is that you urge people to have that death certificate recorded. If it is presented to your office, that may be adequate to satisfy you that that life estate has passed on and is no longer valid. But in 20 years, and somebody's trying to identify, well, what happened, if it's not of record, then it's pretty difficult for people to track that and to follow that in what's called the chain of title. A very common way of eliminating or at least addressing life estates will be also on the face of a deed, where the deed may come into your office with the conveyance, and it will have a certification then as part of the deed itself, where they certify that party A, who had a life estate, passed away on a certain date, and that there were no taxes or transfer issues relative to their estate, and that the life estate has then expired. And that will be part of a certification many times on a deed. Now, the last kind of ownership I'd like to talk about is something that's relatively new. Seems as though the years go by a lot faster than I think sometimes. Relatively new, it looks as though these were added in 2009. I don't know, how many of you have had transfer on death deeds? Almost everyone, okay. It's not something that I have seen a lot of yet. It's another way of owning real estate that the legislature created to create a system that's similar to the way personal property and securities have been handled for many years, where it can be POD, pay on death, or in some cases, in some states, they were called transfer on death, where the property could be individually owned and the person can designate who a beneficiary would be. Until this statute was created in Indiana, that was not a possibility in Indiana with respect to real estate. A transfer on death deed permits the owner to reflect that a beneficiary will be entitled to the property upon their death. The statutes that you may want to review are all in Title 32, 17, 14. That's the entire chapter. This section dealing with Section 11 indicates that the some of the requirements, and these aren't all of the requirements, but they are a process where the deed is recorded where the owner transfers or indicates transfer on death to a beneficiary. It has to be executed and recorded before the death of the owner. If it is not recorded before the owner dies, then technically it's too late. But the concept of a transfer on death deed is that the individual still owns the real estate and still controls the real estate until their death. They have the right to change that beneficiary if they want to. That's different than other kinds of ownership that we've talked about, and which, again, this type of option did not exist prior to these statutes. If an individual were to transfer their real estate subject to a life estate, for example, or if they transfer an interest by a percentage or a fractional interest through a tenants in common, or if they make it joint, that's not revocable. That's not something that they can take back. That's only something that the person who's receiving it would control and could then transfer it back if it were supposed to come back in some way. A transfer on death deed, however, does not actually transfer an interest at the time that the deed is recorded. It is essentially a contingency that would then take effect upon death, much like a POD on a bank account. There's a number of different rules that are discussed in this section. Under subsection E, for example, we talked about the tenants by the entirety. Under subsection E1, if the owner's interest is a tenant by the entirety, the conveyance is inoperable and void unless the other spouse joins. That's because the tenant by the entirety is that special ownership where the two own it as a tenant by the entirety. They own an interest in the whole. One can't convey a part of it without the other. Subsection 2, if the owner's interest was as a joint tenant with right of survivorship, that conveyance severs the joint tenancy, again, meaning that that survivorship is going to be eliminated, and the co-tenancy becomes a tenancy in common. If the ownership was joint with right of survivorship and there was already a beneficiary designation, then the person making the transfer on death conveyance would control their interest in that property for purposes of the transfer on death, but any other beneficiary designation of anyone else wouldn't be affected. Under subsection 4, if it's tenants in common, then that would control with respect to that owner's interest as to their percentage or fractional interest in the real estate. If it's a life estate, obviously the person wasn't thinking about what am I transferring, because it's going to be of absolutely no value and it's inoperable and void, because why? The life estate terminates upon the person's death anyway. And if the owner's interest is any other interest, it indicates that the interest passed in accordance with this chapter. The last thing I wanted you to note here is, if you take a look at the last section here, subsection I, the endorsement of the auditor under the statute we referred to earlier is not necessary to record a transfer on death deed. Why is that? Because there's no transfer actually being made. The person still owns the real estate. Because the transfer on death deeds have not been around a long time, there's been questions what happens upon the death then. And there are some specific requirements as to what's supposed to be filed and recorded to then track that ownership upon the death of the person creating the TOD or transfer on death deed. This is in Title 32, 1714-26, and it's subsection 20. The beneficiary who's claiming ownership is to record an affidavit with the recorder, and again, now the endorsement is required because a transfer is going to be taking place. That affidavit is specifically identifying what information has to be provided, including the legal description, the date of death of the owner, name and address of the beneficiary, the name of each designated beneficiary who did not survive, if there was more than one, and they are to cross-reference the original recorded transfer on death deed. Transfer on death deed, again, it's a relatively new kind of ownership. It's a special kind of ownership, and it's another methodology for people to transfer their assets without having to go through the probate process. So that's one of the reasons why I believe the legislature created this, to come up with another method for people to address their assets without having to go through the estate process. Just as a trust doesn't go through, just as joint with right of survivorship does not have to go through an estate, TOD does not have to go through an estate, but the process is handled through the recorded real estate records with the proper deed and then the subsequent affidavit upon the death of the owner. With that, we've reached the halfway point on this presentation. With respect to the auditor's role and the process of endorsements, dividing parcels, property taxes, and the various kinds of ownership, are there any questions that people have at this point? Yes, ma'am. The question was, with respect to a transfer on death deed, can multiple parcels be combined in a new legal? Frankly, I can't think of a reason why it couldn't, because again, the owner, assuming that the owner does own all the parcels, the owners could transfer the parcel to himself or herself and combine those. And basically, a transfer on death deed is not a conveyance to anyone, but you could even convey it, you might say, A to A, subject to transfer on death to B as the beneficiary, which would be essentially the same as creating a deed for yourself and combining the parcels. You would still require that they go through the proper process for the endorsement. It's not going to be a split, so you don't have to have any maps. Same owner, so you're not going to really have a property tax issue. So subject to going through the transfer on death statutes to see that there wasn't anything that would prohibit that, I can't think of any reason why it wouldn't work. Yes, sir. The question is, if you have a deed that has multiple parcels and combines it into one legal description, do you then? Mhm. 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 That's yeah. The question is if you have a deed that comes in with one legal description consisting of multiple parcels, does that mean that you should combine those tax parcels into one tax parcel number? And uh, um, if there's a spouse, then obviously both spouses would have to be a part of that. It's not going to be. Mhm. Yeah, then the survivor could do a transfer on death deed, yes. Um, that's why it's always, it's always helpful if people that prepare their instruments would indicate on the purpose, on the face of the deed, what the purpose of the deed is. If you're combining parcels and your intent is to create one legal description, the best practice is to put that on the deed so that the auditor and assessors know what the request is being made. We have many, many requests come into our title company where, for building and planning purposes, a parcel has to be created and split off of a main parcel so that it can be permitted for building purposes, or if it isn't large enough itself, it may have to take several parcels and combine them into one legal description for purposes of a parcel and a tax parcel for building purposes. And again, when we do those, we recite what the legal description and the tax parcel numbers are and what the purpose of the instrument is, so that the auditor's office and assessor's office, when they receive those, know what is being requested. I can't, obviously, if you have multiple parcels and they're not in the same taxing district, they can't be combined. If they are not contiguous, they really can't be combined. But if they come up with a legal description and they've done basically a survey to go around all of those parcels, and they've come up with one new legal description, I don't know what else they would be wanting that for other than to combine it into one parcel. But um, it's a good question to ask people, what are you doing? Yes, ma'am. Mm-hmm. Yeah, I think The question, I think, is when you get those kinds of instruments with a survey that combine parcels, at what point do you have an opportunity to review that legal description, review the contiguity question, ensure that all of the real estate that is actually on your records is being conveyed? And I think that goes back to that, one of those first few screens on duly entered for taxation, subject to final acceptance for transfer. We'll talk a little bit more about the transfer process in the next section, but the question is obviously if an instrument comes to the recorder after your office has processed it, and that instrument meets the requirements for recording. If it meets the statutory requirements for a recording of an instrument, we really shouldn't be rejecting instruments, recorder or the auditor. You have the opportunity to reject it for transfer purposes. But for purposes of recording, if an instrument meets the statutory requirements that are required for an instrument to be qualified for recording, there can be errors in it. That doesn't mean that the records aren't going to be caught or that the corrections won't later be required. But the purpose of the transfer or the purpose of the recording is getting that of record. And one of the concerns is always, if you find that there is an error and people are wanting something to be recorded, it's always safer to record it and allow that to later be corrected or to identify what the issue is for the transfer than to either your office or the recorder's office reject something and then have the property owner later come back and make a claim because a problem has occurred in the interim when their instrument did not get recorded in a timely way. Yes? Not necessarily, but the process in terms of the recording is there's certain steps that are supposed to take place before that instrument is recorded, and if you find that there is an error and you're not going to endorse it because there's some significant problem with the instrument, then the recorder is not going to be able to record it. But if there is we'll talk about more of the specific questions later, but if there is an error, but it is not necessarily critical in terms of the real estate records, the purpose for the transfer is for property tax purposes. It doesn't mean that everything's perfect with respect to that instrument or perfect with respect to that chain of title, which would then later be identified. So. Yes? Okay. Okay. I don't see that. I can't see why the others are required. That is an option to have those other two stamps. I question that non-taxable one because unless it's a governmental property, I'm not sure how we're going to know that it's not taxable at the time of a recording. But the statute permits any of those three stamps to then allow the recorder to know that you've accepted it for purposes of allowing to be recorded. With respect to the three stamps, my interpretation would be that the duly entered for taxation would be that you have actually reviewed it and found everything to be okay. And that there's no reason that you're going to reserve rights to not transfer it later. So you wouldn't want to use that stamp, I don't believe, if you feel as though there might be or could be a problem. Yes, ma'am. Splits? Sure. Yeah, the question is with parcel splits, is there a uh, required protocol in terms of which parcel is the parent parcel and which is the exception, or which is the main parcel and which is the subject? Um, yeah, I'm not aware of anything that says which is which. You would, you would think that the um, parent parcel would be the parcel that the property owners are keeping or retaining, and that the other is the one that's going to be transferred or is going to be subject to the separate mortgage or separate easement or something like that. But for purposes of the transfer, I don't think that it really matters, as long as they provide you with the proper drawing that would give you the information for both parcels. Yes. I think if we go back to this statute on parcel splits, that it really doesn't matter which parcel the is the parent parcel, or if they're only doing a survey for um, the parent parcel, I guess as you're saying, and then accepting the other. They are supposed to provide you with information for both parcels. If the surveyor may only be surveying one piece, but they need to be able to provide you with the drawing that will give you the information for both parcels, because you have to know um, where the improvements are relative to those parcels, as well as the number of acres in each new parcel and the location within the original tract of each new parcel being created. So I think that you can require more, but as to the question of which one is the parent and which is the exception, I don't see that that is necessarily critical. Yes, ma'am? Um, Again, there's two different methods where people can consolidate the parcels. One would be through an actual conveyance, and then the other statute is the one where they can make that request of the assessor. That's not necessarily a request that comes to your office. Well, that's a good question in terms of um, when you have parcels that are being combined or parcels that are being split. How do you communicate with your assessor's office, and how do you communicate with your recorder's office? Because this process has gotten relatively complicated in terms of how do you get an instrument recorded. Obviously, if the um, request is going to the assessor is going to need to make or have some type of a method to communicate with your office as to what they're doing for purposes of combining these parcels. Um, That's the way it really should work, is, you know, the assessing official is given the authority to make that determination, but they really don't have the ability to control what your office is doing with respect to those plats and maps and the maintenance of the tax parcel and indices. Okay. Okay. Yes, that's right. It doesn't, like I said before, it doesn't require that you actually do a deed to make a conveyance to consolidate parcels. Um, but that's one of the methods that can be done. Yes? Yeah, she indicates that in her county, they require that the approvals be given by the assessor, the auditor, as well as the planning department. Um, and that, my guess would be that that's tied in with your planning and zoning ordinance requirements. It's really not something that's part of the statutory process here, but it certainly can be tied in with local ordinances. That's kind of the, um, in Elkhart County, it's not a requirement of the process, but many times the question of consolidating or dividing a parcel is generated because of the planning department, and people can't accomplish their building project or their mortgage and loan without having that specific separate parcel created, or to combine parcels to meet the requirements of the planning department. Yes, ma'am. Same taxing district or different taxing districts? Okay. Their county, it sounds as though, has expanded the process to include a review for mortgages. I would say that that's probably pretty far advanced in terms of what a lot of counties do. It's certainly a much greater responsibility to try to track that kind of information down and do that search. I know a lot of county officials are not too inclined to do searches for trying to find pieces of real estate, pieces of the real estate record process. But you're absolutely right. When you have questions about parcels that are combined and a mortgage doesn't apply to the whole thing, it's going to create some issues. They're not insurmountable. what you're doing in terms of trying to minimize issues later with respect to either a tax sale or with respect to foreclosure. You probably will catch some of them. You may not catch all of them because obviously when mortgages are done, they don't necessarily have to utilize the same legal descriptions and the same parcels as what are of record. You're going to have those kinds of issues that are occasionally going to come up where because of a sale, it's going to generate the requirement that a split occurs. Are there any other counties that take the proactive step of checking to see if there's mortgages? Right, right. Yeah, it's interesting too from the front process of doing title searches. When we get orders in for a mortgage, and they may give an address, and that address doesn't always correspond with a particular parcel. There could be other adjacent parcels that don't have an address, and the question is are those supposed to be part of the mortgage? Is it supposed to be part of the title search? That gets into the question of just being, really specific in terms of the records and what they actually represent. Real estate records, as you know, are based upon legal descriptions, not particular portions of areas or addresses, things of that nature. It makes it a much more difficult process where you have to be as specific and accurate as you need to be. We're going to deal with legal descriptions this afternoon on this section and transfer issues. We're going to start with a property tax statute. It's in Title 6-1.1-22. This section of the statute has two different provisions, one dealing with what is an adequate legal description for property taxes under subsection A, and it provides that a description is adequate for property taxes if it refers to the name of the subdivision and lot number if it's been platted, and an abbreviated description with the key number if it is, and the number of acres if the land has not been platted. Subsection B then has a little bit more specifics. If it's real property to be conveyed, it's subject to determination of being sufficient when it is sold for the non-payment of taxes. Again, if it's been platted with the name of the subdivision and lot number. If it has not been platted, reference to the key number and the description, including the number of acres contained in a deed, mortgage, or will or other public record of the county. I don't know, this statute gives me a little bit of concern because in doing the review for this, I found some cases where tax sale deeds were held to be void because they didn't have a sufficiently adequate legal description. I think most of the tax sales that I've seen generally use the abbreviated legal description from the description that's on the property tax card. And whether or not that's in all cases adequate, it certainly should be with respect to the platted real estate. With respect to that's not platted, if your county does not have a description that would comply with this statute in terms of being able to identify that parcel in some way with the key number, number of acres, and a description from some type of an instrument, you may want to take a look and see if your system would be able to be upgraded in some way to provide more of a legal description. In looking at the statutes, this is dealing with just property taxes and, what your records have to have. I also looked at some cases in terms of what is an adequate legal description for purposes of deeds. And you'd be surprised how lenient the courts have been with respect to what is appropriate and what is necessary for a legal description. These are some of the case annotations that I found. The description of a premises will be liberally construed in the intent of the parties if it can be by any possibility gathered from the language employed, it will be effectuated. Descriptions are to be construed very liberally, the intent being to give effect if it can possibly be gathered from the words used. The office of a description is being to identify the lands. Another section where one deed refers to another description of the granted premises, reference may be had to the description in the latter. So if it refers to another deed or another recorded point. Another case, the description is not to identify the land but furnish the means of identification, and when this is done, it is sufficient. These cases are somewhat unusual in that you typically will see courts look at written documents and require specifics. And if you look at cases that have interpreted contracts and interpreted insurance policies, the cases are very strict in the sense that if there's an ambiguity or an uncertainty, the court will find it to be invalid or will be interpreting it against the party that wrote the instrument. But with respect to descriptions, it seems as though the courts are saying we're going to be as flexible and as broad as we can in order to try to support and uphold the intent of the parties with respect to conveying real estate. A couple of others, the description is adequate if it is furnished with sufficient means to identify a definite and specific tract. A description is sufficient if by aids of extrinsic facts pointed out in the description the land conveyed can be ascertained. Ambiguity and indefiniteness in a description may be made clear and certain by explanatory evidence as is admissible under the rules of evidence. Where a description in a deed is such that a surveyor can locate it, it is sufficient. And a description of a property in a deed by a plaintiff and wife as all of the estate, real and personal, that they or either of them inherited as the heir of a certain person was considered sufficient to convey the property. The courts have been, I would say, very, very lenient in the sense of trying to uphold and support the adequacy of a description. Typically, if you have written instruments that are indefinite or uncertain, they will not allow you to look at extrinsic facts. They won't allow you to look at other information apart from the instrument itself. But if you have an instrument that gives a legal description and it gives enough information, for example, under the, this is an 1884 case, Indiana Supreme Court, if the surveyor can actually go out and locate it, that is considered an adequate description. Now, we had a part of this to assist with respect to reading legal descriptions, and I don't know how many of you have had this kind of experience and have worked through legal descriptions, but I put together a few pages here that will you can use as reference and may be able to assist you as you actually work through legal descriptions. I'm sure some counties still have to do it manually. Others may have a computer system that will map for you or a GIS that will verify for you. But the old way, the way I learned it was with respect to sections. Can you all over, can you all see over on this side over here, all right, if I come over here? Can't hear me. A section, a perfect section is a square mile, and it contains 640 acres. Now, not all sections are full, perfect 1 square mile, but a full section would be 640 acres. And if you look here, from a section, you'd have the northwest corner, the northeast corner, southeast corner, and the southwest corner. And then what they refer to as the center section here. And then going around, some of the descriptions you may find will start at what's called the northwest quarter corner, and that's here. I'm sorry, the north quarter corner. The east quarter corner, the south quarter corner, and the west quarter corner. And then if you go around this section, here you have the full section and a quarter section, so that's 160 acres. Here we have the northeast quarter divided, the west half of it and the east half of it. Here you have the southeast quarter, and it's divided the northwest quarter, northeast quarter, southwest quarter, and southeast quarter of the southeast quarter. And then dividing it even further, here we have, this is the southwest quarter. This would be the northwest quarter of the southwest quarter, and then it's divided west half and east half. Same thing on this one. Now we're in the northeast quarter of the southwest quarter, north half and south half. Same thing with the southeast quarter of the southwest quarter. And then you have the northwest quarter, northeast quarter, the southeast quarter, and the southwest quarter of those quarters. And here we're down to, well, starting here you have 80 acres each, 40 acres each, 20 acres each, 10 acres each, and then you can divide those even further. Here we have the southwest quarter of the southwest quarter, and then you can have the northeast quarter of that divided north half and south half, or west half and east half, and dividing it even further down in the furthest southwest quarter of the southwest quarter of the southwest quarter. Now, if you do review legal descriptions that are what are called the meets and bounds, rather than a platted lot, you're going to have references to these areas on a section, and it'll identify what is the starting point in that section for purposes of where do you start to actually map your legal description. And I'll tell you, the most frustrating thing, and sometimes the most difficult thing, is to make sure you got the right starting point, because it is never going to work if you don't have the right starting point. Also, part of doing mapping, if you have older legal descriptions, you will have to make conversions at times. Older measurements were in rods, chains, lengths, and the different measurements as to what those are equivalent to convert an old legal description into a measurement that may be under today's standards with number of feet. You would then have to convert based upon what that legal description is to come up with how many feet. Now, these are typically, you're going to probably be going back 40, 50 years. Most of them since then, I think, have been converted to the number of feet. But if you do need to, this chart will provide that. You can see, like here, how many chains are in a mile, how many links are in a mile. And for purposes of square footage, probably most of you are familiar with an acre containing 43,560 square feet. So if you have the square footage or the distances, you can measure that out and multiply it, and then you can compute and divide by 43,560 to compute how much acreage is in a parcel. Now, if you have a very easy legal description that starts at a quarter and goes a certain number of distance, north, south, east, and west, it's relatively easy to follow. But most of the time they don't do that. This is another chart that provides the conversions for you between the chains, links. Converts those for you to feet. And then with respect to reading most legal descriptions that are metes and bounds, you're going to have directional points which are not going to always be due north, south, east, and west. Now, everybody agrees a circle compass has 360 degrees, right? So from north to east is 90 degrees, same east to south, south to west, west to north. So what you'll typically get are descriptions that will identify a direction as either starting with north or south, and they may say a certain number of degrees east or west. So if you have a description, just for the sake of ease, south 45 degrees east would be here, and then you move east 45 degrees, so you'd be right on the southeast angle, a perfect 45-degree angle. And you can do that, each way. You can go south 45 degrees west would be this way. And your measurements or your directions that you'll have on those old legal descriptions and surveys will be all varied directions and angles. South 90 degrees west is basically due west, but you'll have calls anywhere from 1 degree to 89 degrees, and of course that can be broken down into minutes, what are called minutes and seconds as well. But basically when you do reading the legal description, for purposes of your mapping, you're really not going to have to get to that preciseness of the survey as long as you can track what the angle is or the approximate angle, so that when you have a north certain number of degrees, 10 degrees east, for example, generally what is the slope or what is the angle of that you're going to be going on for a certain distance. And then you'll get the next call. And eventually, you'll work yourself away around that legal description. Now, I have real difficulty when you get into the curves that some description will be based upon. But even with the curves, if you remember the angles and distances, you can generally follow along with what is the general trajectory of what you're trying to move yourself around to come up with a complete legal description to do a drawing. And the point of these is that when you have those legal descriptions, you want that legal description what's called close. It comes back to the point of beginning. And if it doesn't do that, then you've got a defective legal description. Now on transfer issues, the purpose and effect of what you're doing as the auditor really needs to be first and foremost in your mind. When you make a transfer, you are not reflecting or determining who the owner of the real estate is. It may be evidence of ownership, but it's not necessarily the true owner. So if you make a mistake, you might say, and you make a transfer, you're not really changing the owner of the real estate. You're not affecting the legal ownership in terms of who is going to have a right to that property in the future. You're trying to track the information, you're trying to track the owners, and to maintain that chain of title for your records so that they're accurate for property tax purposes. Not to say that you don't want to be accurate, but you're not determining ownership. If there are people or other individuals that may have an interest in that real estate, they may have an interest and you wouldn't even have a clue that they would have that interest. You could have, as I indicated, with respect to estates or with respect to trusts, you could have people that have interests, but they are not necessarily known to you or reflected in the public records. You can have people that make claims upon the real estate as indicated with respect to adverse possession. You could have claims with respect to the real estate that are based upon parcels that were not adequately legally described in the past and left a small gap, left a parcel that was never conveyed. What you're trying to do is you're trying to keep the chain of title as accurate and as consistent as you can with the information you have. But in terms of making a mistake, you're not changing the ownership, as that would be determined ultimately by what the real estate records are as of what are recorded, what is in the court process, and what a court would determine should a challenge be made or brought with respect to who is the legitimate owner or who would have an interest in real estate. What you're doing in making your transfers is you are either accepting that parcel or rejecting that parcel for purposes of transferring the record property tax ownership for tax purposes for your office. It may be transferred on your records to the person who is receiving the property pursuant to a deed, but that is not necessarily going to be determined to be the owner in the future. And should you reject a transfer, you can still allow the process to go forward with the endorsement of being accepted for property taxation subject to final acceptance for transfer, meaning that as you go through that process and determine whether or not all of the parties signed off, whether the legal description is accurate, whether there is an error in the legal description, whether it doesn't close, and if you did not accept it for transfer, you can still reject the change on your records as far as who is going to be receiving the property tax statements. So your process here is, what are your records going to reflect for purposes of the property tax statements? And if you don't accept an instrument for transfer, that simply means that there's no change as far as who the current owner is. That can be changed, that could be brought, they could bring more information back to you with a survey. They could bring more information through a court order. They could bring more information through an affidavit to either convince you or to correct their mistake if there was a problem with the instrument, so that then the instrument could then be recorded, or a subsequent one, to allow the actual transfer to occur. So you can allow instruments to be recorded and still not transfer the property tax ownership for purposes of your records. As we were discussing earlier, there may be a variety of kinds of descriptions or errors that may occur with respect to instruments. One of the questions that I received early on was with respect to outdated legal descriptions. I'm sure you've all seen them that are historical descriptions that have been used over and over and over through multiple transfers, and it refers to the center line of a ditch, a tree, a fence, a stone. Could be all kinds of various locational references that have been used historically. Generally, an outdated legal description is still going to be adequate for purposes of the sufficiency of a legal description. The information would be adequate for a surveyor to go out and actually identify what the parcel is based upon historical evidence and based upon other recorded instruments. Now, if you did have an outdated legal description and through your research and review of the parcel, the history of the parcel and mapping the parcel and perhaps GIS or other computer-assisted technology, if you were to determine there actually is an error in that legal description, that would be an opportunity for you to, again, allow people to record their instrument. There's no reason to interfere with the recording and allowing it to be processed, but you would not necessarily have to accept it for transfer. And that would be the kind of situation where if you found the error, you may want to advise them that, yes, it's been recorded, but no, we have not accepted it for transfer. And that would then allow them to make the correction, get the new survey, come up with the proper, a new instrument that would actually address what the problem has been identified and found to be. Another question that came up was instruments that don't refer to a vacated plat, a vacated alley or street that was part of the description. The case law on real estate descriptions of this nature generally would favor the interpretation that the main parcel description, an accurate description of the main parcel, would carry with it what are called any appurtenances or other rights that were associated with that parcel without them actually being described. So again, my recommendation there would be if an instrument comes in that had gone through a process where the street or adjacent alley was vacated and property ownership was divided, generally it's through the half, and each property owner on each side of it gets half of the vacated parcel. If that description comes in without that vacation, you could allow that to go through and make the transfer without the specific reference to the vacated alley or street on the premise that the main parcel carries with it the appurtenant rights. Now, that may not be right. There could be unusual circumstances where somebody actually retained that little strip of land. In most cases, it would probably be the intention that it was to go with the main parcel. But again, if you make the transfer and it's wrong, that doesn't mean that you've changed the ownership. People could still come back in and make a claim upon that land, could make corrective instruments, perhaps get a court order, whatever would be necessary in order to determine that parcel was supposed to have been retained. But in most cases, I think you'll find that that's the intent is it was simply overlooked, and there was no intention for a person to leave a 8 1/4 foot strip of land, for example, behind without any other ownership that person had. Another question had to do with quitclaim deeds that are less than the whole. If I own a parcel that is 20 acres, I can do a quitclaim deed for 10 acres. That just simply means that the other 10 acres I didn't do anything with, and the 10 acres, which is quitclaimed, is what the transfer would be. In other words, what a person owns under one parcel or one legal description does not have to be conveyed if it's through a quitclaim deed. You can quitclaim a portion if you wish to. Similarly, a quitclaim deed of more than the whole raises questions. A quitclaim deed, behind it is nothing more than the person saying, I'm giving you any and all right, title, and interest that I have in this real estate. So I'm not warranting, I'm not certifying, and I'm not assuring anyone that I actually have that legal description or that real estate, but I'm conveying whatever interest I do have. So if, for example, I owned a quarter section and I conveyed the entire section through a quitclaim deed, what did I do? I quitclaimed the acreage I owned, the 160 acres of the quarter section. All of your other real estate records for that section would be a no change. I didn't own them, so I couldn't make a change. But there's nothing defective about that quitclaim deed. It conveys the interest that the owner had in that real estate. Then various defective legal descriptions. As we talked about, when you map a legal description through the various distances, various calls and angles that are provided, you may have a situation where you've got a chain of legal descriptions that has been used over and over again, and when the description was prepared for the current conveyance, they missed one of the calls. They missed one of the descriptions between the various directional references that are provided. That would be a missing call, and it would be a defective description. It would go absolutely nowhere. Another kind of defect is a description that does not close. It does not come back to the point of beginning. If you have a description that let's just say for the sake of argument, it went 100 feet by 200 feet by 100 feet and then came back 100 feet to the point of beginning. It doesn't come back to the point of beginning if the call was for 200 feet necessary to close that. So that would be a defective legal description. It would not close. It would not actually encompass and encircle the description of the parcel that was intended to be conveyed. You could have historical calls where the same legal description was used and one of the calls has a typographical error in it. One of the examples given was a call that starts with the northwest corner of the northeast quarter, but the person doesn't own anything in the northeast quarter, and it was supposed to be, a different quarter of the section. Again, it's a defective legal description because it does not identify any real estate that the individual owns. These kind of things raise questions in terms of, okay, what's the best way to correct that? Now, if you've got the person at the counter and you point out the descriptional error and they're willing to take it back and get it corrected, that's perfect. If they insist that it's right, they insist it should be recorded, they insist it needs to be recorded for one reason or another because of whatever transaction they've gone through, there's nothing that would prohibit you from accepting that property but not accepting it for transfer and allowing it to be recorded. Obviously, the description has an error, and at some point that's going to need to be corrected. You could also have descriptions which are inadequate in some fashion, simply do not describe a description that would provide you with an evidence or information that would allow you to identify the parcel. So if you had a deed come in, for example, that referred to Lot 10 in a subdivision but did not give the name of the subdivision, again, that would be a defective and inadequate description, is not providing you the location. You could also have ambiguous or indefinite descriptions that may not be able to provide you with any location information or could give you multiple locations because of an inconsistency in the description. So if you had a person that had multiple lots in a couple of subdivisions with similar names, but none of the actual names of the description matched any of the subdivisions, that there was some type of an error, you'd have an indefinite or an ambiguous description as to what were they intending to convey. All of these give you examples and reasons why you would not accept the instrument for actual transfer on your property tax record cards. But that would not necessarily mean that you wouldn't allow a document to be recorded if people are going to insist upon that instrument being recorded. Instruments to be recorded have to meet certain legal standards which are established for the recorder's office. And if they meet those standards and they meet the requirements for your office in terms of providing you with the breakdown of the parcels, for example, as to the acreage and information if it's a split. If there's an error in that, that wouldn't necessarily mean you wouldn't accept it to allow the process to go forward. If you have those kinds of situations, my advice generally is if the people want that instrument to be recorded and it otherwise meets the recording requirements, you allow it to be recorded and the recorder would allow it to be recorded. But you would not necessarily accept it for transfer, and at that point that would be a signal to them that there was a problem and it needs to be corrected. I think at this point we can open it up again for any questions with respect to legal descriptions, transfer issues, and if anything else came up with respect to the various kinds of real estate ownership or the roles and responsibilities of the auditor, we could entertain all of those at this point. Yes, sir. The question is, with a deed that conveyed a parcel that included 3 tax parcels, but as one legal description, whether or not that should be accepted or whether or not it should be required to go back and divide it up. Do you have any idea why there are separate parcel numbers? Generally, you can only combine, certain legal descriptions based upon those being contiguous, and if they're in the same taxing district. If they're not, then there can be a problem for purposes of your tax parcels. You have to be able to identify the properties in each particular taxing district to maintain your controls with respect to assessed values and things of that nature for property tax billing. But if the parcels are all contiguous and if all the parcels are in the same taxing district and they have one legal description, there isn't any reason to reject an instrument. And frankly, I'm not sure that there would be any reason why you wouldn't want to combine them into one parcel, one tax parcel, if that's what the people had anticipated. But part of the problem with with this process is that you don't always have a good paper trail of what occurred. It could be that the people had provided that original legal description with the premise that it was going to be combined, and somehow it got slipped through the process, and the actual combination into one parcel never got accomplished. It sounds to me as though that would have been a situation where they were at one point individual properties, individual legal descriptions with parcel numbers, and somebody got all of them and then did this combination. Other questions? Yes, ma'am. Wow. I think the question is a description adequate or defective if it gives the main parcel and then gives exceptions by all of the conveyance references for the other instruments? Boy, that's certainly not something you want to see. I'd have to tell you that based on the cases that I saw in preparing this, it seems to me that's probably adequate. The description of the land where the court held it to be adequate, where the person referred to all of the land that they had inherited from somebody, is even more more generic and more burdensome for anybody's office to try to track that down. The other is that with those references, the case that talked about giving reference to other instruments, it seems as though that with that information it would be adequate. It's really, I'm sure you've had some situations as well that are frustrating where you know, the main parcel has 14 exceptions, and every time that the conveyance comes in, you get this deed that's 4 pages long with all of these legal descriptions. And at some point, you just wish that they would go out and get a survey for what's left, because it's pretty hard to figure out what is the remaining parcel after you take all of those exceptions. At this point, I don't find anything in the statute that requires that a person go out and resurvey. Any other questions? Yes, ma'am. The question is if you have a call that brings you back to the point of beginning, but it's pretty clear based upon the other parcels in the area that is not the proper distance to bring you back to the point of beginning. Does that point of beginning call control or eliminate the discrepancy to make that description adequate? That's, in my view, that would be a close issue, because there are differences that are found by survey when you actually go out and survey real estate, because sections are not all perfect, and if you have a section that is not a perfect square mile, if people come from different beginning points, they will not necessarily match up. When you're talking about a few feet, 25 feet, it's possible that that is an error. It's also possible that there is just a historical description that is not accurate based upon what the actual section is, but that it would actually close if it was, if it was resurveyed. So I think that would probably be one of those situations where it would be best to accept the deed and perhaps not accept the transfer if you are convinced that there is an error and that needs to be fixed, or if you, based upon the historical chain of title and the historical references for prior deeds, if it's been the same, then you may actually even accept it for transfer as, potential error or defect, but not substantive. Any other questions? Sure. Sure. Okay. Mhm. Yeah. The question is on affidavits of heirship. Typically, you'll find that, and then all of those heirs will sign off on a conveyance, or some of them will sign off to the others to get the owner into one or two of the kids or something like that. But also seeing a situation where a deed comes in and there was never an affidavit, but the deed itself provides the recitals as to who the heirs and beneficiaries of a decedent was, certifying that that's all of them, and waiving any claims that they might have to the real estate to transfer it. Again, a lot of those of you that have been in this business for a long time probably have seen that there are a lot of certifications, recitations on deeds that are used as part of the conveyance process in order to clear up those ambiguities or uncertainties as to who might be a beneficiary or who might have an interest in real estate, eliminating, for example, life estates, confirming who might be related relatives for heirs. I don't see that there's a specific requirement one way or the other. I've seen it done both ways. Again, you're relying upon the certification in the deed just as you would an affidavit, and as long as that appears to be consistent with what your records are, I don't know why, I wouldn't have any reason why you wouldn't accept that for purposes of the transfer, knowing that if somebody has been left out, which you wouldn't know, and they still could make a claim, your records don't eliminate that as a possibility, and that person wouldn't lose their rights by that. But again, knowing that in this day and age, things like identity theft, things like fraud and forgery, you're going to have to rely upon the validity of the instruments that are provided to you, and as long as they're consistent with the records that you have, I wouldn't see any reason why you wouldn't accept that, whether it's an affidavit or a deed.